some of that property during the search of that, and that some of that was obtained potentially with monies derived from the sale of marijuana. Is that, I'm just trying to wrap my head around the whole scenario here.
But you have to understand, what I just answered is the ATF under federal law. This is the state of Michigan. They have a Medical Marijuana Act, and the state just
but the scheduling, sir, of drugs at the federal level supersedes the state.
Yeah, but this is a state court we're in. It's the state laws we're under. It's not a federal prosecution.
Understand.
They don't apply federal law in state court. And the concept of that you're speaking of it being, Schedule 1 is absurd. This legislature just passed a law where they're going to receive tax money for selling these things that this argument would lead to, that my client was possessing, and it's contraband. May as well be kiddie porn. I mean, that's the analogy.
Was extraction legal when the search warrant in Michigan, when the search warrant was issued?
That's a good question. I don't know that it was ever illegal. I know that there was an opinion about brownies, but I would suggest that the preparation thereof of the Michigan medical marijuana, usable marijuana, has never been litigated. Now, I know law enforcement was arresting people if it wasn't plant material, but that was not a resolved issue. I would say brownies maybe, but that this legislature fixed. And the real answer is no, it wasn't, because the law that you pass is retroactive. So the answer is no. When he was possessing so-called extraction machine, asking me today, it was lawful because the law is retroactive.
Another issue too is
right?
They claimed that was so.
I'm just thinking, Mr. Chair, for allowing this, but I'm just trying to wrap my head around if the law enforcement agents may have been acting in lawfully under what they presumed was the intent of the law and how the law was written at that time that they made the entry into the residence and seized the property.
Understood. His wife was not bound over, meaning the charges were dismissed against her. So that would be the first answer to whether the law enforcement were acting appropriately. There was no probable cause to find that crimes existed in the case. Now, Mr. Fisher's case, we had to litigate, and ultimately it was the court found that there was a medical use. The medical use defense was found to result in the dismissal of the charges. But his point is making that no one recognizes that there's this medical purpose, and if you prevail, then there is no forfeiture, and they're not contemplating that.
Thank you.
Thank you.
Thank you very much. If there's no additional questions, thank you for your testimony. Next, we have Ted Nelson of the Michigan State Police, retired, who has supported the bill and would like.
Mike's still on.
I bet that dude was going to do.
Cole? All right, well, Mr.
Cole.
Camoran. Yes, that's right. This is why you take your lawyer with you into situations like this. Because the cops in this state have been trying to out-argue Michael Camoran for a very long time. And they just can't do it, not even through a little ventriloquist like Tristan Cole. They can't do it. It's not possible.
Well, the point is, we don't think they would be in a position to even ask those questions. Sharmi is of the firm belief that they were getting text messaged by other observers in the court posing questions to try to challenge the testimony of the witnesses. The most distressing thing is that despite the really overwhelming presentation, because first, in the, I'm saying, Representative Lucido presented a tremendous opening statement of why it was so important. He played a videotape made by the Institute of Justice. There was an odd character that was called to. He was kind of indifferent about it, which is weird. But then we had a number of different people testify, and then of course the law enforcement committee, Steve Miller from LEAP, and our friend Ted Nelson, who was the original OG MSP forfeiture police officer. He trained them all. And he sees it as turned to a real abuse. And he saw it coming, and he sees the problems of it, and recommended that this is one of the paths to be able to end the abuse that's going on. Steve Miller's points on behalf of LEAF were really fascinating, too. He said, I would like to believe as a former police officer that the officers themselves would have enough confidence in the strength of their case to be okay with this. Like, if you got a good case, then you don't mind waiting till you convict. You know what I mean? And it would seem fair. They would probably, but unfortunately, the other side of this is that the motivation on the decisions to take property that falls in the category of subject to forfeiture is that the decision to take it results in those takers keeping it, and those takers being the direct recipients of the proceeds of it. It's not going into anyone else's pockets other than the persons who are seizing it. Now, some of the interesting things that came up that have always been suggested, like if there has to be forfeiture, would it be better if the funds were placed in a general account through the state, or they were designated for schools, education, or roads, or something to that effect, but certainly not exclusively returned to and benefited from by those that made the decision unilaterally, by the way, to seize it, right? And while statistically in 2010, I'm sorry, the 2016 report, is that the last one? Yeah, the 15 million. I think it was like 10 or 11% of those cases were administrative forfeitures of that amount. 10, just people that didn't respond. And then there was a number of other, like 15 to 20%, which involved cases that were pending, but the forfeitures had already been, the criminal cases were pending, but the forfeitures had already been resolved. So that would be like another, 25, that's like 30, 40% already. But so you see that it's not $400,000, or $1 million homes and boats and jets. It's a lot of, $3,000 to $5,000 scores, as they say. But as it was weird that these people were questioning so hard, because as I was trying to explain to Sharmi afterwards, the whole point of their challenge to me was not really, even relevant to what was going on. The fact was we beat the case, right? That's really that highlights that, okay, we're here, they're fallible, like they can be beaten. The case thrown out, bad search warrant, meaning there's some judge out there that's got the courage to do that. And Fisher dismissed on Section 8. But this didn't come about by me cheating somebody. I'm there because these things were entered in a civil, in a criminal, but in a court, right? So I'm there with documentation of the system that we're all trying to be part of and uphold and make sure that it works. And I'm there with the orders showing that these things happen and suggesting that they were victims because the forfeiture occurred before a conviction could have even been had. And had this law been enacted, they then would not have been victims of that. Miss Jocelyn, Amanda would not have lost her house, and the Fishers would not have had to deal with, not having their property for 2 years. And Steve, I think, testified, he's been with our clients when they get their property back. Who wants it back after 2-3 years? Or the TVs, you've probably moved on, gotten other ones maybe, or some of the other personal things are in the clutches of who? All your things have been tainted, broken. You can't get back to them, and it's very, very frustrating. But the point is that this was not to be a relitigation. The case is those were over. I'm there to claim that the property wouldn't have been taken. It would not have been an issue if this law had been effected. Missing the point of the entire, so all those attacks on me, whether they were justified in taking it and blah, 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 that wasn't the point. What was then was then. And the result was we won. So but even if they did that then and this law was in effect, it would not have resulted in their seizure up front. What's the story with that? Do we decide if there's over 50,000? How does that play out?
No, there does not. There's not.
Wasn't there some catch-all on that?
Note of.
What do we got, Fraser?
Let me find it.
Is there a maximum volume? I'm sorry, maximum amount on that bill that remained the same?
It only amends the sub 50,000 section. It does not amend the administrative forfeitures over 50,000.
Right, so they can still forfeit.
Same practices above 50,000.
It only is for that small window of the 50,000.
Yeah.
Do you understand that? That's what it is.
I don't understand it.
It doesn't
say
change that.
anywhere here.
It encourages, from his perspective, the forfeiting of people that are less than $50,000
That's fine.
in value, right?
Discourages that.
Discourages it because
I think
Right.
it's going to be really interesting when somebody's like at 45. Like the people that are estimating this are the police
well,
in all cases, and I think it's going to actually do some very weird things when they get. I think they're going to start estimating things wrong, taking extra stuff to get over the hump,
Threshold.
so to speak. It could have some really damaging effects, actually, the more that I think about it, for people right around that area. But who knows? I mean, it's all bad police behavior.
You know what, though? But those kind of things are measurements that can be, are better to be challenged than.
Yeah, there are no more forfeitures between 35 and 50,000.
we're still taking away a massive amount of their ability to kick in our doors and take our stuff, especially
Not
with
kicking the
45
doors yet. They can still kick in the doors.
Well, we're still taking away a massive amount of
This-
incentive if they've got to get a conviction. I believe.
Interesting. Where
Don't
would
rain on
where
my
would grow
parade,
lights
Chad.
fall?
No,
on
no,
this?
no. It's
10
going to be,
years.
it's
Where would
gonna
grow
be
lights
much
fall?
better.
10
Where would
years
grow
I've
lights
been
fall on
doing
this? Where would grow lights fall on this?
Well, grow lights,
They're
as you
cheap.
know, in 2012.
Where would they fall on this? Would they start taking them as evidence?
Oh, right.
Well, they can
there you
sell
go.
them.
Now
No.
they're going to have to. They're going to
No,
have
under
to.
this law, they wouldn't be able to
apply
take it. They
inflated
take down the
prices.
plants. They can't. They're not going to take the grow lights because there's no conviction, right? So they're going to leave them there. They have to leave them there.
Well, I think they can take
They
whatever.
do that a lot now.
Do
Well,
they?
well, that's what they usually do, right?
Yeah. They leave
Tristan
the grow
Cole
lights
is a
behind.
schmuck.
There you have it.
What was that?
Listen. The real problem here is that we have cops in the Capitol, and Jeff Frazier likely remembers a phone call we had maybe a couple of years ago with other folks in Georgia, California, New York, ourselves, with other people that were facing the same kinds of challenges with law enforcement agencies in the capital of their state circumventing drug policy reform. And this is really the thing that we've got to eliminate. It's not the first time that we've had law enforcement agencies show up at a hearing where we have high hopes for some kind of reform. I'm going to play a little clip right now. Let me set it up a bit. This is October 1st, 2014, the SWAT reporting bill hearing McMillan put up. They called us in there to testify, no vote, because their only reason for calling us in there was to slap McMillan around the cops and chew him out for how dare you do this to us. So I watched Amy Denner, your buddy, Jim Powers, Sergeant Amy Denner from the
Sergeant
Michigan State
Slaughter,
Police,
yep.
hand talking points to these representatives of the Judiciary Committee, and then we watched them read them. Here's what Clint Kesto had to say about McMillan's bill, which just asked like 5 questions. Did you shoot anybody? Who signed the warrant? They were very basic questions that we wanted answered. Here's Kesto.
Now, we will take up testimony only on House Bill
Oh,
4914
did you
from
did you put it at
our
10?
friend Representative McMillan.
No, at 10 minutes, yeah. So, yeah, sorry, I sent that to, it was at the bottom of the thing. So,
Unfortunately, I've been hanging around Chad, and the incompetence is spread.
Imperfections.
Proportionally higher.
Why are y'all so mean to
Maybe we
Chad?
need to look into it further. Are we comfortable that 90% of these are for,
here's McMillan. This is Representative McMillan explaining his
nonviolent
bill.
or non-barricaded gunman situations? Should we look more at whether we should allow that to be happening? I mean, these are traumatic situations, and I think they deserve a spotlight to make sure that locals and the citizens, the 10 million citizens in Michigan, understand what's going on when we're talking about the most physically violent action we allow the government to do.
Here's House Representative, former Wayne County Prosecutor
Thank
Clint
you, Rep. Kesto.
Thank you, Mr. Chair. Representative, did you read the facts or the warrant or anything from that Kalamazoo case or no? Do you know if they had a reasonable belief to enter that location?
This is a kid. This is where a kid in Kalamazoo was shot by the police.
Did you read the warrant?
I read that they were apologizing for their mistake.
Okay. Right.
Police.
So that's a no. My other question is, how many places in Michigan don't keep this data?
All of them.
Don't keep this, compile this data? How many law enforcement agencies?
I'd love to know.
Okay, do you know?
I think everybody should, and I think they should freely give